Welcome. Right at the top of the hour here, we're going to give us about 2 minutes, and then we will get started. Many of you have attended these before. Always know I get panicky about making sure you can hear me and see the screen. So if you don't mind, if you just maybe raise your hand to make sure the technology is working. Excellent. Thank you. Thank you. Very good.
I was waiting for that question from Aaron, like clockwork.
Sure. Snacks.
Yeah. One day maybe.
One day. What we do is we'll just get Aaron's address, and then we'll send him personalized snacks, which he will fully appreciate, I'm sure, but we'll just tell him that everybody else got the same package. So let's see. So I've got about another 30 seconds and we will start. Okay. Well, I am Brian Klontz, president of Charitable Solutions. I've got my colleagues on the phone today. So Ryan Raffin will be helping to quarterback a bit of this and running the slides. And then we have Sarah Hawk, probably new to many of you, who've been with us almost exactly 2 years. So a little bit more of an introduction of her as we sort of get started into the agenda. So she'll be taking us most of the way through and did 98% of all the content. So she'll be most adept to be able to walk us through that too. So what are we talking about today? Real estate investment to real estate impact, utilizing Delaware Statutory trusts, known as DSTs, as a charitable giving option. And we attempt to try to make these monthly webinars as timely and obviously as relevant as possible. And Ryan and I were talking about sort of what the next topic should be. And we had at least 2, maybe 3, but I think at least 2 questions that came up in the last 30, 45 days on DSTs, and from actually some of our clients who do a lot of sophisticated planning, just saying they've never even come across them and how do they work. And hence, here we are today. So what are they? How do they work? How can they be applied to charitable planning? So again, Ryan will be sort of helping through, and Sarah will be doing most all the content. Similar to all of our past presentations, as you know, quick housekeeping, we will not be providing directly the slides. We will be providing them indirectly with a full recording. And so I hope some, if not all of you, have gone to our Charitable Solutions LLC.com website under resources, and then all of our past webinars, I think at least 35 now, all free, can be downloaded. And if there's one you particularly like, I guess you could watch it 14 times with your own personal snacks. Don't know why you would do that, but you could. But I do hope in all seriousness that if there are particular things like, yeah, DSTs, they don't come up much at all, I will guarantee you within the next 3 to 4 months, it's going to come up. So that's just how life works. And you might say, I was kind of listening to Sarah and it was pretty good. I didn't remember all the detail. And oh my gosh, something just came up and it's a Thursday and you can just hop right on the site, obviously, and watch all or salient parts of the webinar. That's the goal. So really developing a library all around both giving overall, but obviously more of the non-cash and CGA giving more specifically, since that's what we do. So with that, Ryan, I guess if you want to jump in back to what we do, if you can forward the slide. These are our 6 primary areas. Again, many of you have heard this often. Some of these are relevant when I say them, and a week later something might pop up. But our mission over the last 20 years exactly now has been to help make charitable gifts happen that otherwise wouldn't. And so we do that in 6 primary buckets. I won't call them divisions. We're not quite that large, but sort of at least business lines. So Emergency Assistance Fund Administration, sort of top right there. We do that through a charity I created called the Emergency Assistance Foundation, doing a lot of grants for these Maui fires in particular right now, very, very painfully. But we do global grants. You can see there it's about 12 million employees that we now cover through it's about 380 different large employer funds where we're able to do disaster and personal hardship grants through a public charity portal. So sort of risk managing that process, which is what strangely gets me excited. But to be able to help, again, these gifts happen that otherwise wouldn't. And the grants received in the Maui fires and COVID and all the other grants that we make are all tax-free, in particular domestically. Professional Advisor CE, it is that time of year. So after Labor Day until the week before Thanksgiving, I am on the road about half the time at least. So going to Lafayette, Louisiana here on Thursday and Friday, Kansas all last week. But the point is we do things like this, which are hopefully educational, both for professional advisors, for CE, usually on site, and then for board members, donors, nonprofits, et cetera. So staff, so any kind of training there. Charitable appraisals. This is an area, smaller sort of thing, line of what we do, but growing one of the fastest. And that is our tagline is, if you can give it to charity, we can appraise it. And that includes obviously split interest gifts like CGAs or CRTs. And so you can see all the different things that we appraise there. I do the virtual currency and life insurance appraisals, and then we have multiple other people within the team doing all of these other types of assets. So being able to make sure that's a qualified appraisal. And then sort of the next two buckets, I probably ought to reconfigure these to be sort of top and bottom or side by side, but are gift annuities. So if you go sort of middle top, gift annuity risk management, do a lot of gift annuity audits for larger pools. When I say a lot, it's probably 12 to 15 or so a year. And then for particular charities that are either trying to sort of exit the business or have a very large gift annuity or group concentration of gift annuities within their pool, we do analysis and design as appropriate of either partial or full reinsurance brokerage and placement. So we've got, I don't know, 15 or 20 reinsurance contracts going through this week. And so that's not very typical, frankly, but it's probably about 15 or 20 per month that we work with charities on, sort of where that is otherwise appropriate. So that's the CGA risk management. National Gift Annuity Foundation, also very quickly growing line. I think we've got maybe 85 to 90 gift annuities that we've done so far this year. Interestingly to me, it was a shock to me, frankly, that about a quarter of those have been QCD to CGAs under the new Secure 2.0 Act. Got a whole webinar on that, as you may or may not know. So that is growing very quickly. We are registered in all 50 states. I have 600 contracts there. It's probably closer to the 750 now, so I need to update that. About 65 million in assets, so it's growing very quickly. Bottom line is, for those charities that don't want to issue gift annuities at all, or are not registered in a particular state, or some of which are trying to transfer a smaller pool and sort of exit the business, and that way, or if it's for an illiquid gift or a more complex type gift, or perhaps a very large donation that they don't wish to take themselves, back to our mission, we help make these charitable gifts happen, in this case, gift annuities that otherwise wouldn't. So if you're in Texas and you got a donor in New York and you're like, we don't want to register in New York, because you shouldn't, for lots of reasons. Painfully, we have registered in New York, and then we're able to bring that in. You can see there, one of the bullet points is then 100% of the residuum is then granted back to the charity or charities that the donor was trying to give it to in the first place. So that's how we operate. And from a risk management standpoint, we're managing the asset, the liability, all compliance, payments, tax reporting, and so on. And very similar to that, about probably 65% of our 27-person team is working in the non-cash space. Ryan leads that area as the managing partner. Sarah works with him probably 15 times a day at least. And that is, we are a national donor advised fund that does nothing but take in illiquid or complex gifts. We do that, again, through our donor advised fund, such that we are doing the due diligence. We are providing the substantiation letter, obviously donor advised fund, and so forth, that, again, other charities might not otherwise take in a gift, like a DST as an example, like international property, any kind of illiquid gift that comes up. You can see their average donation is about 4.4 million. We average roughly one per day. You can see their average fee is a touch under 1.4%. That's held back at the time of settlement. So then roughly 98.5 cents on the dollar, then 30 days after we receive that liquidity, is then granted out. So the liquid funds do not stay with us. We have just under 2 billion or so in current assets in that foundation, all illiquid, all at various stages of sale, roughly 200 different positions. So don't say no. We always say good donor wanting to do good things with a good asset. So the next slide I'll touch on for about a minute and be able to transfer this over to Sarah. So this is our 2022 DECMI non-cash, does not discuss the CGA or CRT or incorporate the CGA or CRT activity at all. Key point right there in the parentheses, 100% of the gifts that we complete were declined. So we do not market to donors. We do not market to advisors. We only market to charities that, based on either it's a very quick turnaround or a complex gift, or they could do it June 2nd, but not December 15th, any of those cases that otherwise they were going to decline, we say, don't decline the gift. You can refer that over to us or other peers, competitors that we have in this space that do a great job as well. It does take us, we get about 8 to 10 roughly on average, 8 to 10 referrals per day, just in the non-cash space, not the other areas I mentioned. And we complete about 1 a day. So a lot don't go through, a lot aren't conducive for it. They might have a lot of debt, might be a timeshare, but 1 does. And those that do tend to be very large. So you can see the breakdown, 154 last year. We had done about 200. I think it was 260 the year before-ish. You can see there a bit over $500 million in donations, all captured that otherwise wouldn't have been. We have real estate and then business interest sort of deconstructed there. It is weirdly the same percentage that we did in 2021, where we had received about 1.2 billion in total donations for that year. This is about half of that, but when you break it down by real estate business interest, it is oddly consistent. So proportionally is about the same. So as I'm passing this now over to Sarah, we're talking about sort of the real estate piece, kind of the business interest piece as a blend, which are these Delaware statutory trusts. So here's the agenda. Before I hand this over to Sarah to sort of go through, she has been with us like exactly 2 years. I think another 2 or 3 days she'll be here 2 years. She just completed, super congratulations, the CAP, Chartered Advisor in Philanthropy Designation Program, and cannot get her designation until she's been with us 2 years, which is like Friday. So congratulations on that, but has done an incredibly good job for us. We call her a sort of project manager, but basically it's that Brian and I are having those discussions. Very often Sarah is on the phone for all of the preliminary discussions. And then once sort of the gift process is designed, it's passed over to Sarah, and she sort of takes it all the rest of the way through, managing due diligence with the rest of the team, doing a lot of the due diligence herself, managing the, making sure all the paperwork is executed appropriately, and really just shepherding each one of these 100+ gifts, 200+ gifts through the sort of over the goal line, if you will, and then through actually the full sales process. So with that, Sarah, thank you for everything you're doing. I will pass it over to you to hit the agenda and educate us on DSTs.
Thanks, Brian. That was a great introduction. So for the agenda today, we'll start by discussing DSTs for real estate investments and how those can be utilized for real estate gifts. We'll also touch on the considerations for gifting real estate outright versus through a DST. Those include considerations for the charity and for the donor. Then we'll touch on the DSTA and trustee responsibility since the DSTA's 2020 amendments. And then we'll discuss advantages and disadvantages for DSTs. And finally, the IRS's prohibitions on powers of trustees, also known as the 7 deadly sins of DSTs. So with a general overview of DSTs for real estate investments, we know that DSTs are a legal entity created under the Delaware Statutory Trust Act. They are a real estate investment vehicle, allowing investors to pool their funds together to be invested into a single property or properties. This allows investors to not have to actually manage the property, and there's limited liability in the DST structure. So essentially, investors are owning shares in the trust, which qualifies the DST as like-kind real estate property eligible for a 1031 exchange. So the 1031 with the DST, this allows the investor to sell the investment property, initiate the 1031, allowing for capital gains tax to be deferred. those tax deferred funds can be invested into a DST, and then the charity can be named as the beneficiary who receives income on the DST asset. The DST can also have income going to the initial investor, or the charity can receive DST proceeds as a gift. We'll be focusing mostly on transferring DST interest, whether that be to a CRT or to a DAF. But that's worth touching on, that there's different implications on gifting DST proceeds or gifting DST interest to charity. Now, there's different considerations for donating DST interest to a CRT or donating DST interest to a DAF. They're similar in a lot of ways, but the real difference is that the CRT transfer is going to allow for income to be generated. So when you're donating DST interest to a CRT, you can get the fair market value deduction for that transfer. The charity can be named as a beneficiary of the CRT, which again would allow for income to generate to the CRT that can be shared amongst the beneficiaries, including the charity beneficiary that's been named. At the DST's expiration, the remaining DST assets would be distributed to the charity. Now, if we're considering donating DST interest to a DAF, some portion of the DST interest can be gifted to the DAF, allowing again for the charitable deduction at fair market value. This is similar to donating real estate outright as well, which we're going to touch on. That portion of the real estate can be sold tax-free when the DAF sells the real estate. So that's the benefit of using a DAF for the CRT or for the DST interest. However, again, there's no income to the investor because that's just when the DST is transferred to the CRT. However, the charity can invest the assets. Next slide. Thanks, Ryan. Considerations for an outright gift versus through a DST. There's going to be some charity considerations there, and then there's also going to be considerations for the donor. A lot of those will revolve around the tax implications. As to the charity is going to want to start with some questions. Are we comfortable accepting real estate? What are the gift parameters on accepting real estate? What's the time and cost going to be for accepting real estate? And the importance on income being generated to the charity itself. If the charity can handle real estate and the donor's not looking for income, or the charity doesn't necessarily need that income right away, then an outright gift of real estate might be best. However, if it's the reverse and using a DST wouldn't require the charity to manage the real estate, a DST could be an option, allowing for that income to generate. And then the charity can either roll over the proceeds from sale or be cashed out at the time of sale. Now, the implications for the donor are going to be first, whether the donor would first need to consider whether the property qualifies as 1031 exchange property. So there's rules on whether the property has been held for a long enough time period and whether it meets the intent requirement for 1031 exchange property. Gifting real estate outright versus through a CRT will allow for a charitable deduction and avoidance of capital gains. A donor will need to consult their CPA and attorneys to see how this could play out in both scenarios, but it can be found through gifting real estate outright or through a DAF or CRT. Now, if capital gains tax can be incurred by just gifting proceeds from the DST. So we're not going to talk about that much. We're mostly going to focus on transferring DST interest to a CRT or to a DAF. But that's something also to consider when considering outright gift of real estate or a gift through a DST.
And before we flip to the next slide, Sarah, which I just did, one thing that I wanted to mention just occurred to me as you were going through this. The donor who's considering this gift even if they are giving a DST interest, they're still going to have the normal 8283 requirements, and particularly that appraisal requirement is still going to be in play. And that's something that I would think a donor really would need to understand. And again, that's going to apply whether it's an outright gift of a DST interest or a gift to a life income vehicle like a CRT or even a charitable gift annuity. There's still going to need to be that appraisal. And I think that's going to be a considerably more complex process and a more complicated appraisal than it would be for sort of your standard real estate appraisal, which is generally a pretty straightforward process. Those are normally easy to obtain for donors. Typically, they either know an appraiser because they're in the real estate investment business, or a realtor who's going to be selling the property would know an appraiser. For residential real estate, those are very low cost. They're very quick. A DST, that's a more complicated structure, more complicated mix of assets inside the DST. So that's going to be more time consuming to obtain. It's a more specialized appraisal. And I think the cost is usually going to be, I think, meaningfully higher as well. So that's something donors should keep in mind.
Thanks.
And then a question just came in, and this is probably a good time to discuss it as well. Debt encumbrances with DSTs, and the question referred specifically to the problems of transferring debt encumbered assets to a CRT. But I think debt encumbrance in general is an issue. And did you want to cover that later, Sarah, or do you want to talk about that now?
We can talk about that later a little bit more, just generally with debt encumbered assets.
Okay, yeah, so we'll get to that latest question at the end of the presentation here.
Great, and I think we're ready for the next slide. Now we're going to talk about the DSTA, which is the Delaware Statutory Trust Act. It largely governs Delaware statutory trusts, and it's been changed quite a bit over the years, but specifically in 2020, when it had its amendments. In those amendments, we saw that contract law is a big part of the DSTA and governing DSTs. And we also saw the importance of trustee responsibility, and that was clarified quite a bit in the amendments. Some of the most important DST trustee responsibilities are importance of the trust agreement and adherence to it, asset management, communication and reporting, and fiduciary duty. So that first one being the importance of the trust agreement and adherence to it. The DSTA and the amendments make it clear that the trust agreement, that initial instrument, is very important, and there's certain things that, if left out of the instrument, could affect some of the transactions of the DST. So in the 2020 amendments, one of those was clarified, and it was made clear that the DST can be bound to contracts entered into by its name or by anyone acting on its behalf, unless otherwise stated in that governing instrument. As to asset management, trustees have a passive duty when they manage the assets, and they also have a broad power to delegate power to persons to oversee the business operations of the DST. So that's an important responsibility of the trustee. Communication and reporting. The beneficial owners of the trust are entitled to certain information about the DST as it reasonably relates to their interest, and that is set by reasonable standards of the trustee. The amendments clarified that the trustee can limit these standards as they relate to the books, records, and other documents. So the trustee needs to have good discretion and know what's in the DSTA and what the governing instrument allows and limits. Fiduciary duty. This is another very important responsibility of DST trustees and trustees in general. The DSTA doesn't define fiduciary duty specifically to DST trustees, so we look to the common law duties of care and duties of loyalty. That duty of care being the trustee having to make informed decisions, and the duty of loyalty being that the trustee must act in good faith in that their actions are in the best interests of the DST. Now, advantages and disadvantages of DSTs. We're going to talk about those generally when making gifts with DSTs, and then separately as to transferring DST interest to a CRT and transferring DST interest to a DAF. So generally, the advantages of using a DST are that they're attractive to real estate investors, again, because of that low investment amount to participate. That's because lots of investors are included. And then some other attractive points to real estate investors would be the limited liability structure of the DST. DSTs can't be terminated by beneficial owners on their own accord or by their bankruptcy. And again, investors don't have to manage the property. Using DST for gifts, you can get that charitable deduction at fair market value. There's an advantage of controlling the income stream that allows investors to provide the payout rate and name beneficiaries of the DST. And then advantages when transferring DST interest to a CRT. The main one here is going to be the income that generates to the donor or beneficiaries. So that can be the charity as the beneficiary or other named beneficiaries, such as the investor's heirs. The advantage here also is that capital gains tax can be deferred. That would be until the CRT sells the DST interest or until beneficiaries receive income from distributions. There's also distribution freedom in the fact that the funds from the DST can go directly to the charity or charities as they are named beneficiaries. The advantages for transferring DST interest to a DAF is a little bit different. So with DST interest to a DAF, you would be playing that advisory role on the DAF. There wouldn't be income generated. However, the DAF could invest some of the income that it receives, and then capital gains tax can be eliminated when the DAF sells its DST interest. Also, those capital gains tax may be entirely eliminated with a CRT if those beneficiaries are in a lower tax bracket or if they are tax exempt. So again, some similarities between the two, income being the biggest difference there. Some disadvantages for using DSTs for gifts would be the tax responsibility to beneficiaries and heirs, the fact that you have to rely on the DST sponsor, and then market risks that could affect the DST and its value. So tax responsibility to heirs and beneficiaries. Will there be capital gains tax flowing to beneficiaries? Possibly. Capital gains tax may flow through to beneficiaries by the CRT at income distribution, depending again on the tax status of the heirs and beneficiaries. So it's important here to consider whether heirs should be part of your estate plan. If you want your heirs to be included as part of your estate plan or as part of this gift in particular, using the DST structure would allow for them to be named as beneficiaries and to receive income. And even though capital gains tax might flow through, depending on their tax bracket status and their tax exempt status, it could be so little that it would actually be eliminated, the capital gains there. Relying on the sponsor is another potential disadvantage for using DSTs. That's essentially because when you're using the DST structure, you're losing that control over management decisions that rely on the trustee. If you're gifting DST interest to a DAFT, you have to consider the fact that the DAFT may make investment strategies that aren't the ones that you would have preferred. Same with grant recommendations. You can give your grant recommendations to the DAFT, but they're not going to be required to follow those. So there is that risk of losing control there. There's also market risks, which is a very big one since we're discussing real estate here. DSTs have a long-term holding period. They're typically between 5 and 10 years, which makes them highly illiquid. As such, the value can be affected by that holding period being so long. And of course, they can be influenced by economic factors as well. This would result in less dollars to charity or less income to beneficiaries if the value does decrease. Liquidity is something to also consider here. These are very illiquid assets, so they may not be readily converted to charitable gifts. And then illiquidity of DST interest in a CRT can limit income distributions if the CRT is relying on that income from these assets. Changes in interest rates are something also worth touching on here. These can affect property financing costs, which can influence cash flow, or CRT investments made can reduce the income to beneficiaries as well. This is
Sarah,
why.
Yeah, go
Sure.
ahead on the due diligence. Yeah, due diligence is super important. That's for sure. But a question came in, which I knew you were going to cover this, which is perfect. But I wanted to wait. But one of the questions that came in was, so when a donor's contributing the DST, in particular to a CRT, but could be to a DAF as well, is it assumed that there will be an immediate sale of the DST, sort of going to your point that you can sort of get that liquidity? So I think you sort of answered that here. I just want to tease that out, that you generally are not able to sort of sell it immediately unless there's some underlying real estate that is planning to be sold. Obviously, you can get a potential assignment of income issues there. But usually this is sort of a longer term hold for at least many of these, or I guess somewhat theoretically, although I don't think we've had experience with this, you could take the DST and then sell it in essence at the secondary market or to other potential DST holders of that particular one. Clearly at very likely a discount, very likely a very steep discount. So just to sort of tease out your points here around market risk, longer term holds, that you're making a great point about if it's a CRT, you got to have liquidity that might necessitate the need to have them in the CRT as a flip, CRUT as an example. So you have to sort of anticipate what liquidity otherwise you may have or would not have within the DST. So just want to sort of tease that point out.
Yeah, and I might add to Brian's point, and this goes to a question that came in that Brian already answered. Why the focus on outright gifts and CRUTs versus CGAs? I think that really, Brian and Sarah's comments really goes to why not CGAs, because with a CGA, the appeal is, and the requirement of the annuity contract is that you have that certainty of payments, and you just may not have that with the DST, and that makes it maybe not the best fit. I don't think it's impossible to fund a CGA with a DST interest, but I think an immediate gift annuity would be very tricky, and even a deferral period, that may or may not work very well. So I think that's why CGAs maybe are not the best fit for this type of asset, particularly given that CRUTs do have that flexibility, the flip option or the net income with makeup option. Either way, you've got something that's a little better adapted to the nature of the CRT and the particular risks that Sarah's been talking about here.
Thanks, Ryan. Just to wrap this slide up, those disadvantages, especially the market risks, it's really important to have that careful planning and due diligence, just for the charity to know if they're comfortable with the asset value and with that potential holding period. And then for the donor investor as well, because of those potential market risks, they would probably want to see a very clear exit plan as much as possible. But just again, it's important to have that careful planning on both sides.
Yeah, and the due diligence, you're right, Sarah, is vital. I know we got to flip to the next slide here, but it's kind of twofold due diligence, right? The donor has to do their own due diligence to select the DST, and then the charity of course has to do due diligence to decide if they want to take this donation. So there is some trust. The charity has to have some trust in the donor's ability to assess these assets. Which is something that we've talked about on these webinars before. Anytime that you're taking really any kind of complex illiquid asset, there has to be a certain element of trust, and that's where you as the charity who's accepting this needs to consider your own risk tolerance and policies, and whether your knowledge of the donor, your knowledge of the asset type makes you comfortable accepting, in this case, a DST.
Finally, we're going to discuss the IRS prohibitions of powers on trustees. This is also known as the 7 deadly sins of DSTs, and it comes from IRS ruling, Revenue Ruling 2004-86. So essentially, again, this is the 7 deadly sins of DSTs, and I've worded it in such a way that we can clearly see what the trustees can't do. And I'll provide some rationale on that as well. So one of the first ones is that trustees can't make future capital calls after a DST offering is closed. This is because investors get that pro rata share in ownership based on the initial investment. So future contributions could dilute someone's ownership share. And that's hence why the IRS has this prohibition. Number 2, trustees can't negotiate existing loan terms. This would actually hurt the investors who have completed what's typically a lengthy due diligence process to participate in the DST. And that's also after the trustee has disclosed initial loan amounts. So again, this prohibits that initial investment from being impacted by not allowing trustees to negotiate existing loan terms after that initial round of funding. Number 3, trustees can't reinvest funds from sale. This is important because it's essentially to the point that trustees must distribute beneficiaries their distributions. So this clearly prohibits trustees from being able to reinvest funds from the sale, and instead they have to distribute them to the beneficiaries, and the beneficiaries from there can either cash out or roll over the proceeds into a 1031. Number 4, trustees can't make capital expenditures improvements except as to a few exceptions, which are normal repair and maintenance, minor non-structural capital improvements, and those required by law. What this does is protects the beneficiary's investments from ill-fated capital upgrades. Number 5, trustees can't invest liquid cash other than in short-term debt obligations. There's usually cash available for additional investment after DST offerings are closed. So this limitation allows for the trustees to make quick, thoughtful improvements that can increase the DST's value without putting the investments at risk. Number 6, the trustees can't fail to distribute cash to co-investors on a regular basis. Again, this goes to the point that trustees must regularly make distributions to the beneficiaries. And this prevents the misappropriation of funds and ensures that they are paid their distributions regularly. And finally, number 7, trustees can't enter into new leases or renegotiate current leases. There is an exception here, that being for bankrupt or insolvent tenants. Trustees could enter in new leases or renegotiate current leases on their behalf. But this one seems a little questionable. So there's actually a way around it, and that is through the use of a master lease structure. This allows the DST property to be leased to a master tenant who could then take on the responsibility of entering new leases and renegotiating current leases. And so that allows for this to still be done, just not done by the trustee, and it takes that decision off the trustee.
And just as you're going through that, Sarah, I mean, to the extent that we've talked about the market risk, and maybe that looks like the significant downsides for a charity considering accepting this type of asset, I think these protections here are really favorable, obviously, to all DST investors, beneficiaries. But I think it's important for a charity considering accepting this type of asset to understand that these protections exist, because these are really strong protections that prevent the trustee from striking out on their own with unusual investments and like you said, capital expenditures that might fail or simply just be a waste of money. These are really meaningful protections, in my opinion.
I agree. These, especially with the amendments to the DSTA, I think give charities some comfort that the value, although there could be some economic factors that play, it does protect the initial investment when they're looking at considering a DST as a gift.
And we've got quite a few questions coming in, so I think if you want to go over this final overview, and then we can discuss some of these questions, and then I had some comments that I wanted to make as well. So I think we should have lots of time here to get to all the questions.
Sure. So as a final overview, we've discussed DSTs as a real estate investment tool. Those are attractive to a lot of real estate investors because of that limited liability structure through the trust, the low participation amount because there's lots of funders and investors are pooling their funds into one single property or properties. There's also the perk of not having to actually manage the property, which can be attractive to both the investor and to a charity who may be looking at a gift of DST interest or being named as a beneficiary. DSTs for charitable gifts, they allow for the charitable deduction at fair market value. If you're gifting DST interest to a CRT, that can generate income to the charity and to other named beneficiaries that the investor wants to include. This can defer capital gains tax, and it can possibly eliminate capital gains tax depending on the beneficiaries and their tax status. This is also attractive for charities as a gift in the sense that, again, they may have less work in not having to actually manage the property if they receive DST interest. This again drives the important point of due diligence and careful planning, both on the donor's part and the charity's part. It's going to require significant planning from the donor's CPAs and attorneys. We touched on the DSTA and the importance of the trust instrument. This is also important for the charity to consider when looking at a gift of DST interest. And then the tax implications to the investors and the beneficiaries. We saw that as part of looking at DST interest to a CRT. Do we want heirs to be included? Will there be capital gains tax passed to beneficiaries? And then, of course, what are the tax implications going to be to the donor investor themselves? Finally, we looked at the IRS's prohibition of powers on DST trustees. There were quite a few, and these actually can be helpful, especially to the charities, as it can protect the investment value and hopefully result in more money to charity. So now we can take a couple questions.
Yeah, so let's see. There was one that just came in where the asker was saying, assuming their charitable organization chooses not to accept DST contributions, could they work through us to accept these types of gifts and make distributions to their charity when applicable? Now, this is a question we love. It's easily answered. Yeah, we would certainly consider accepting a DST contribution. And what we would do is we would have your donor set up a donor advised fund with our org and have a standing grant recommendation for any cash to be granted onward to your organization. So, so we would be the ones accepting the gift. We would hold title, issue the donation acknowledgement letter, sign the 8283. All of that would be done by us as the donor advised fund, accepting and holding the interest while it was in a liquid position.
And I would only add to that, all that correct, of course, that it still obviously goes through our due diligence, of course. And I would say, I don't know, I'd probably say that 350, maybe 400,000 sort of minimum would be. So we do get calls from time to time about, can you take one of these? And, absolutely we can. And it's, $37,614. And that's just not, given the appraisal pieces that have been mentioned and other due diligence. But I would say probably that 350, 400,000 would probably be around the minimum. So unless there's other, a quick liquidity or something else that's going on that could make it much simpler than sort of a longer term hold, all things being equal. But would agree with all of that. And I do have just, it looks like there are 3 hands that are up, and it could have been when I originally asked if you could hear us and see the screen. So if you actually are wanting to ask a question, just to be clear, it looks like everybody should see that the Q&A box is the best place to do that. We do scrape that, by the way, all the questions today and then all the ones from Thursday, and then we include those questions and answers in with our final recording that will be sent to all of you next week as well. So if you could just include any questions that you might otherwise have in the Q&A, and then we can sort of answer those as we go through. So what's the next one, Ryan, that you've got maybe in there? We've got Russ Willis on our team, sort of our internal tax person that works with Sarah all the time, making a couple of good comments too about sort of the rental property not generating revenue. And as Sarah mentioned, sort of these, if you can't make additional, in essence, capital contributions, in some cases it generates great revenue, and then all of a sudden it needs repairs or something else that's going on. And then that could, all that income could be immediately diverted to, those expenses. So what you see today might not be what you see, next month situation. Here's a question here that's, I think, a very good one. So the question is, and Sarah, if you know, or maybe if Russ, if you know too, but do DSTs pass to heirs charity at death by POD or payable on death forms, or perhaps a TOD type form? And then do all DSTs sort of work the same in that regard? Are there any any disadvantages to charities to receive them, or are there times that the charity should otherwise disclaim? So I guess I'll maybe answer the last part. Is there are always times that the charity may otherwise disclaim, including us for that matter, for all kinds of reasons that might come up within the due diligence period. But on the actual passing, obviously you've got the beneficiaries of the DST, but when we're talking about in essence, the beneficiaries from the beneficiaries, I guess, sort of if they're trying to get that over to the charity itself upon their death, my presumption is, and which I'm probably wrong, is that there actually is, in essence, a beneficiary form, and whether that takes the form of a TOD or POD, it sort of in effect works out to be the same, in that it would be outside the probatable estate and so forth that would then be going to the charity directly. But Sarah, did you sort of see anything in your research sort of about that specifically?
Yes, well, with the DST interest going to a CRT, that would have it would end up with the charity instead of the heirs and beneficiaries when it's gifted to a CRT. Let's see.
But if it's through an estate, so let's say I don't give it during life to the CRT or to the DAF, and I simply say, if I die with this, I want this to go to outright charity or to a donor advised fund, as an example. I guess the question is how do you actually affect that at the end? And so how is that affected? I mean, it's got to be some kind of beneficiary form, clearly, but I don't know if that takes if it's technically a transfer on death or a payable on death type account. I would think it'd be a TOD, but it could just be simply a beneficiary form. But I didn't know if that's come up, or Ryan, and the ones that we've worked on. And I guess I'll take a big step back as you're thinking about those things. We don't see a lot of these. We got a number of these questions. We actually don't do a lot of these transactions. Again, weirdly, this has come up a fair amount in the last 45 days. But I do think that this is going to come up more and more. You've got issues with sort of this, again, huge mass of baby boomers retiring. A lot of the people, I sort of joked with Ryan, but it's true that, somebody's 27 years old and they buy a duplex and then they do a 1031 like kind of exchange, and then they do like 13 more of those. That's probably not a joke either. And then they get to the point of like, okay, we're sort of finished with managing the 2 or 3 apartment complexes. Maybe we're 65 to 75 years old and we will sort of start downshifting some of our responsibilities. Then they're sort of thinking about, well, do we sell or do we do another 1031 exchange, either into perhaps a tenants in common interest, which we actually see a fair amount as well, or into this more DST higher end, typically single property sort of animal. I believe I'm also correct, and then it sort of has to be an accredited investor that sort of is doing this. So it's a little bit more of a sophisticated type transaction. But the point in all of that is then now they're in the DST, then the question is now what do they do? And so that's where we're seeing that those that are charitably inclined that now maybe are 75 to 85, and they're thinking about how can we maximize some charitable gifts, get some current deductions, income tax deductions, versus leaving it through our estate and losing those income tax deductions. That becomes a little bit more of the conversation. So it's a lot more the baby boomers, sort of the end game from all the 1031 exchanges. And now if they're charitably inclined and there's very low basis, obviously, since that's been depreciated down over time, then that becomes a very typically conducive charitable donation, but for all these other considerations Sarah's mentioned and debt and so on. So anyway, but I guess, are any thoughts on the issue relative to the actual transfer itself in terms of at death? Or it's got to be some kind of benefit, obviously beneficiary form, but we haven't.
Yeah, I'm not certain
specifically. Yeah.
We got a lot of questions coming in here. So I think we should probably discuss some of because a lot of these questions have to do with CRTs. So I think we should discuss the CRT question and how kind of broadly how that might work. But let's see. Does due diligence include an environmental study? I would say it depends on the mix of real estate in the DST. If it's residential real estate, you're maybe less concerned about environmental study. If it's commercial real estate, that becomes more of an issue. Certainly, because of the due diligence that's going on with all of these other investors into the DST, I would expect that there is one or more existing environmental studies kind of already in existence. When the charitable discussion comes up, the DST should have those already, if it's the kind of property that calls for that sort of thing. In which case, yeah, you're going to want to look at the phase 1 and phase 2 if they have a phase 2 also. So yeah, it depends on the type of real estate, but probably you do want to look at the environmental study if it's available, and it probably will be. Let me see. Yeah, question about why less charitably minded donors would use a CRT for real estate that, like Brian mentioned, had been rolled through maybe multiple 1031s when they could just fund it into a DST. Yeah, certainly you're going to run into that with this type of donor. They tend to really have a strong aversion to capital gains, and they're going to be looking to maximize tax benefits in a lot of cases. So if they're strictly comparing the CRT to the DST, the question is how much do they want that upfront deduction that they're going to get from the CRT, whereas with a DST they're not going to get that. So that deduction might be something that factors in to the analysis for the donor, even if they're not really super charitably minded and they don't really care about that remainder beneficiary on the CRT, that being the charitable beneficiary. So that might be one thing. But otherwise, yeah, I think any CRUT that's funded is probably going to have to, it's going to need to have a flip provision, and probably net income with makeup as well, would be my expectation here. I think the donor's going to want that. I think their advisors are going to want that, and I think you as the charity, you're going to want that as well. Let's see. Sarah, did you see anything, because you mentioned the lifespan of these funds? There was a question about sort of whether they all work the same, or do they have kind of standard windows for liquidity, standard time frames? Can you speak to that a little bit?
Yeah, not standard timeframes. That's why the due diligence aspect of this is so important. What's important to hit on, I think, is that rental income can be generated. So even if it takes some time to get liquidity from actually selling the property inside the DST, that income can still be generated. And that's helpful to charities and beneficiaries when using a CRT. But no, not standard times for liquidation that I've found.
What about, and this one just came in as well, what about the reasoning behind limiting the trustee powers so significantly? The question was why the trustee is so limited as to his powers.
Yeah, I think a large part of that is to keep it as a trust. It's not, even the trustee can't actively manage business operations. So I think a lot of the prohibitions are for that reason. They don't want the trustees to be too actively engaging in reinvesting sales proceeds or negotiating new leases. So I think that is a large part of the rationale for those prohibitions.
Great. And let me see. Oh, one of the first questions about underlying debt. Obviously, a debt encumbered property into a CRT is going to be a significant problem. I mean, and more broadly, even if it's not going into a CRT, it's just an outright gift, that underlying debt you could see, I would think, some UBIT issues there. But if there's significant leverage, the donor is also going to have bargain sale problems, which may defeat the purpose of doing an outright gift. So I think significant debt can be an issue, particularly if it's going into a CRT. If it's an outright gift, the UBIT may not be necessarily something that is a problem for the charity, assuming they are getting enough income to pay any associated tax liability. But in that case, the donor really should consider the bargain sale element as well. And I think Russ just followed up with some comments that Delaware law allows free transferability for these interests.
Well, I'll let everybody in on a little secret who's still with us here. So we were wondering, are we going to have enough content for Sarah to take us to the 1 o'clock hour Eastern time here? And of course, yet again, we did. So it was great. I appreciate very much all the questions. So this has generated more questions than a number of our past webinars, which is great, which means this is something that people are interested in and are perhaps either hearing about or have had some experience in the past, but it's not a new thing, but it's definitely coming up more and more to be sure. So something hopefully that this provided you some information on helping your clients or your donors. You can see here the past 3 webinars. I think I forgot to add the August one, so we've done this every month here for a while, so you can see that. But right there on the charitablesolutionsllc.com, and then under webinars there. So all the past ones. We do hope this is helpful. Thank you so much for your time today. I think we are dead on the 1 o'clock hour, again, Eastern time. If there are any questions, or I should say differently, if there are any suggested topics that perhaps we have not covered that you think would be helpful, let us know. I've got 1 or 2 in mind for the next couple months, but the first 10 are always easy. And when you get to like 40 or 50, you start thinking about needing some help with some more topics. So definitely let us know. But this will be coming out next week. Again, for those of you who we were not able to answer the questions, we will be doing that, adding those with the ones that we get from Thursday. So those will come out next week as well. So you'll have the benefit of that. So thank you very much, Sarah. Fantastic job. Thank you, Ryan, for helping be our a guide here today. And again, hope everybody found it helpful. Thanks so much. Have a great day.
Thanks all.
Thank you.